Hi, I'm Karyn Vanderwarren. I'm an attorney who practices estate planning in the Chicago area. And today I wanted to talk to you about powers of attorney for property. A lot of times when I do estate planning, the client focuses on the will or the trust, which is a very important part of the estate plan, but powers of attorney for property are also very important. So what is a power of attorney for property? It's a document that allows you to name an agent who could act on your behalf and make your financial decisions for you in the event that you're unable to make decisions for yourself. For example, if you became incapacitated. You can also use them for other reasons, but I'm going to focus more on incapacity as the reason for this discussion. One thing that is important to know about a power of attorney is that once you name somebody, you can change it at any time. You can revoke the power of attorney, so you're not stuck with what you decided. If situations change later, you can change it. The other thing is that you can limit the time. So you could make a power of attorney effective immediately, but you could also have it become effective upon other events. For example, upon written determination by your physician that you are incapacitated. The benefits of having a power of attorney in place include the fact that it allows your agent, the person that you have selected, to act on your behalf. They could go to the bank and use the power of attorney to handle banking transactions, or your financial advisor. They can even help you sell real estate or other things that maybe you're no longer able to handle. Another huge benefit of the power of attorney for property is that it could help to avoid a guardianship proceeding. What is guardianship? Guardianship is when the court appoints a person to act as your guardian. So the difference is, in a power of attorney, you're selecting who will handle your business for you. But in the case of a guardianship proceeding, the court is deciding who that person will be, and it may be a person that you wouldn't have selected yourself. Don't forget also that you can remove the person that you named as agent at any time by revoking your power of attorney. One important point that people don't realize is that upon the death of the person who created the power of attorney, the power of attorney ceases to have effect and is no longer valid, and then the will or whatever other estate planning documents you have in place will take over. This is really important to realize because I've had situations where I've had clients that say, oh, my mom made me power of attorney, and I have to explain that, no, that power of attorney is no longer good upon death, and if there's no will, it creates a problem. So it's in the case where an estate holds real estate, who's going to pay the mortgage and taxes, and where will those funds come from, is a really serious question, and it can reduce the amount of money that you would get from a house, or even put a house into a position where they could go into foreclosure. I hope that this information was helpful to you. Obviously, it's not intended as legal advice, but it is intended to give you some information to help you decide if you need to discuss this further with an attorney. Please feel free to contact me if you'd like to discuss your estate planning situation. Thanks again.